Wait, what? I can do that? This is Eric Bell with Wait, what? Financial matters that matter for business and the people that own them. If you missed last week's episode on foreign nationals, please tune in. It was an excellent episode with Cullen England. Welcome to this episode of Wait, what? Financial matters that matter for business and the people that own them. I'm fortunate today to have Teresa McQueen with me. She is the founder and principal attorney for Sapphire Legal, which is an employment and risk management law firm. She's a skilled attorney, and she says a recovering litigator. So that's one step at a time, I think, huh, Teresa? One day at a time.
Hence the smile on my face.
Yeah. Teresa earned her reputation for as being a zealous advocate while maintaining a successful working relationship with her opposing counsel. She also is the host of Workplace Perspective, raising the bar at workplaces everywhere. Law podcast focusing on education, training, and the law to help organizations of all sizes develop and maintain successful employer-employee relationships. Thanks for being here, Teresa.
Thank you for having me.
You know, risk management comes in all kinds of forms, and I know today we're talking about employees and employment policy. You know, what types of questions should businesses be asking during the interview process when you're trying to bring a new employee in? What type of questions should they not be asking? What type of questions should they be asking? Or what's allowable now?
Well, there's the easiest way to say it, there's two really big no-nos right at this point. So one has to do with California's existing and recently updated ban the box legislation, which prevents an employer from asking about an applicant's criminal background history until after a conditional offer of employment has been made. So that's super important. And then the other big one is, of course, not asking about prior salary history, because now, according to California, you're not allowed to make employment decisions based on prior salary.
So California only, or is it nationwide, or is this several states?
Yeah, so federally there's also protection, but in California specifically is just sort of gotten on board. And
so if I'm looking for a job, I should say I made $1 million the last time.
That used to be the thing. So I remember when I was a young professional and you're trying to, move up the ladder or get a different job, that would always be a problem if you, for example, took a job where you had more benefits for less pay.
Right.
It was always difficult because the first question you could ask was, what was your prior salary? And even in law, when I was a young attorney, I took a job where I had more benefits than pay. And when I was trying to look at moving out, making a lateral move or moving to a different firm, I had a problem with recruiters because they didn't want to work with you if your salary wasn't at a certain level.
Right.
So it really is a barrier to employment. And so as part of the law and basically, kind of public policy, we want people to be able to move freely from job to job based on their qualifications, not necessarily because one business wasn't willing to pay them what they were worth as opposed to another business who maybe paid them more than they were worth. Because it's really not an indicator. I guess that's the thing.
I guess I remember on applications, there was a spot there what your previous salary was back when.
Yeah.
Wow.
And I know that that's more, a lot of that has to do with just making sure that the person has the right expectations. Mm-hmm. But I think the better thing to do would be to put on the job announcement a pay range. For example, like big companies typically already have pay ranges for certain jobs.
Right.
So you can come in at the floor, you can come in at the ceiling. And you kind of know where you're at.
Depending on what your experience is.
Right. Yeah. That would be a little bit better than to say to the employee, I'm applying for a job. My last job just didn't pay as much, but I have all the skills. Well, it's likely they may not even look at you. I don't know.
Well, that's on the front end. Let's talk about the back end and we'll cover the middle. What's the biggest risk associated with terminating an employee? Just to get those two questions. So we got it coming in. What's the biggest risk associated with terminating an employee?
I think I have a little bit of a different philosophy on this. I know people are going to want to hear a technical answer, but let me give the more philosophical answer first. So I think when it comes to terminations, it's really the how and the when. So the how has to do with how you're actually terminating the person. And if you're not being mindful about how you're doing it, in other words, there's so much sometimes that satisfaction in that whole, you're out of here.
Right.
You screwed up for the last time. You're done.
You're fired.
Yeah. But those are the employees that go talk to attorneys because typically those outbursts happen in front of other people or in a way that's degrading or humiliating, and they feel disrespected and they don't feel good about the situation. You can terminate someone, even someone you're angry with, someone who has made a huge mistake, in a way that helps maintain their dignity so they don't feel at least disrespected. Nobody's going to be happy about losing their job. If you can manage that difficult conversation in a way that makes that person feel as respected as they can be in the situation, and that you're considerate, you're mindful, you're not doing it in front of other people, you're trying to treat them, again, with as much civility as you can, it's going to go a long way towards whether they pick up the phone and call an attorney. I can tell you from experience that the majority of the calls that I would get as a litigator would be people talking about the fact that they felt morally wronged as opposed to actually having experienced unlawful behavior, because it's that sense of disrespect or that moral wrong that they really have a tough time getting over.
What if you have an insubordinate employee? I mean, they're just doing all kind of bad things, and you just want to get them out, so you're firing them for that reason. I'm trying to understand their feelings at that point. They've been insubordinate consistently
Right.
in front of other people, and now you're getting them out. Is that still a challenge for people or for employers?
It can be. Again, I think, so the other part, so that's sort of the how. The other idea, I think kind of what you're getting at a little bit is sort of the when.
The what for.
Yeah, and the what for. So the when kind of talks about that. So when you're terminating someone, you need to stop and look at the bigger picture. What's going on with this employee? Did they just notify you that they were pregnant? Are they attempting to return to work after a temporary disability? Did they just complain about inappropriate conduct or something like that? So what's going on with this employee? Because the optics of that are going to be part of that risk analysis. If you have an employee who is insubordinate and you're terminating for performance issues, my biggest piece of advice on that is to always go back to your policies. It's always best to support. I know people want to build a record against someone, and to me, there's benefits and costs to that, because the more records you build, people aren't stupid. They know when they're being set up to be let go. And there's an argument, we're in at-will states. You really don't have to have a reason as long as it's not an unlawful reason.
Right.
So if you come in and I don't like the color of your tie today, so long as I'm not terminating you for an improper and unlawful reason, I can terminate you. I don't have to document the fact that you wore an ugly tie 6 days in a row and it just got to me and I couldn't take it anymore. I know that's sort of silly, but the idea being you want to make sure that, again, you're not looking like you're just nitpicking, because those records, when they get to build a record, it tends to look nitpicky. Mm-hmm. Like, this person's been late for the past year and a half, and it's only been in the last 3 months we started documenting it.
Right.
Every single time they're late now, we've got this paper trail, so we're good.
We had an HR professional on, and one of the things he talked about is being consistent and starting early and having an employee handbook. Or an employee type of, an employee handbook is what he talked about. We've got to
I think you have to have policies and procedures. I think especially in California, you really shouldn't be operating without them. And it really is a guidepost. If you're making a termination decision, again, it's better to be able to go back to a policy that you have, that the employee was aware of, that they violated. That's going to be your motivating factor, especially if you're faced with, if that's close in time to something else where somebody did complain about unlawful behavior, or they are just returning to work, or something like that, because those cases tend to be mixed motive. In other words, something like, if somebody tells you, I'm going to have surgery next week and I'm going to have to be out for 3 months, and you go, well, that's great, and the next week you terminate them, just the proximity, just the temporal nexus between the time that they informed you and the time that you terminated that relationship, that had that adverse employment action, can actually be evidence of harassment and retaliatory conduct.
And that's so obvious, but I've heard that happen before. Things like that happen.
It happens all the time. Yeah. It does happen all the time. So that's what I think, that when you need to be really mindful. Now, in those sorts of cases, if you have a legitimate reason, a valid reason, a lawful reason for terminating someone, and in proximity to that, there happens to be something else that happened. Like I always tell people that say, oh, I plan on terminating them on Friday. I'm like, why are you waiting until Friday? Right. If you're going to terminate someone, terminate it, because you don't know what's going to happen between Monday and Friday.
What about this waiting till 5 o'clock, kind of when everybody's going to leave? And, so it's kind of done after hours, so no one sees it, so they can exit with dignity, gather their stuff.
I do think that there's some merit to that. Okay. I do think that if you think that it's going to be an issue, or it's going to be a problem, I always suggest that if you are terminating someone, if you have an HR person, to have that HR person with you in the room, or someone else, especially if you think it's going to be a difficult termination, just for everybody's sort of comfort.
It just seems like a really wrong thing to have someone work a whole 8 hours.
I know.
That hurts. If I was going to get fired, I want to get fired at 9 o'clock in the morning when I get in.
Right? And there's nothing wrong with that. It's this idea that, because then that goes back to that moral part, right? Because they're going to think the exact same thing.
Right.
At 5:10, when they're sitting in their car, totally devastated. They're thinking about those things like, well, those people knew all day long. How humiliating is that? I talked to this person 3 times, or I knew they were avoiding me. Mm-hmm. Those are the things that people have a very hard time getting over. Wow. That even that initial insult, that or salt on the wound or whatever, however you want to view it, that's tough to get over because it makes them feel bad about an already bad situation.
That's right. It just seems like employment law and employment situations are it's a moving target. What can a business owner do to protect themselves in your mind from a legal standpoint?
I think the best thing to do from a legal standpoint.
Or from a lawsuit, I should say.
From a lawsuit, there's not much you can do about protecting yourself from a lawsuit. And okay. I think that's one of the biggest things because you can't stop someone from talking to an attorney about what their rights are. You can't stop someone from feeling as though they have a claim when maybe they don't have a claim. Or maybe it's just circumstantially looks like there could be something there. So they go talk to someone. So I think that coming to that realization is important. You can't prevent someone from testing the waters or finding someone who's willing to send out a demand letter to see what's there. Maybe there's something, maybe there's not. But I think the one thing that businesses can do is make sure that they are aware of what the law requires. And there's a difference between knowing what the law requires and acting on that. And I think that a lot of businesses forget that while the business is yours to run, the risks are yours to manage, you still have to comply with the law, whether you agree with it or not. Find this where a business owner maybe feels some moral issue with regard to whatever the law is requiring. You find this with bathroom requirements. So when the transgender issues are now becoming more prevalent and the bathroom has become a big issue in the workplace in the last couple of years because of some changes in the law. So there's a lot of people who may feel morally different about what the law requires, but you have to realize that you are a public face. You're a business. You still have to comply with what the law says, whether you maybe morally agree with it or you don't. It's like taxes. You have to pay taxes regardless of how you feel about whether or not you should be paying those taxes. You still have to pay your taxes.
Some of them anyway.
Yeah, I don't want to get into all that. You know better than that. Yeah. You know way better than that. But I think that so just be aware of what the law requires because ignorance of the law is never going to be an excuse. And so you're always going to be held responsible, whether you're relying on a tax professional, whether you're relying on a third-party leave administrator or benefits administrator. You're always on the hook. So it's really to your benefit to know what the law says and to be aware of what's going on. And then the other thing I always suggest is quarterly audits of employment practices. And I say that because if you do nothing else, quarterly audits of your wage and hour practices are super important because the Private Attorney General Act, PAGA actions, which maybe people are very familiar with, they're very popular right at the moment, and they're a lawsuit that allows an employee to stand in the shoes of the Attorney General to determine whether or not there's any similarly situated employees who are experiencing violations from that employer. And it can go from very egregious things like not paying the minimum wage when you're supposed to having the wrong information on your wage statements. So a quarterly audit of your practices makes sure that if there's something wrong, you're catching it early. And you can figure out what to do with it if you've made a mistake. So fixing a wage and hour mistake within a quarter is going to be a lot easier than fixing a wage and hour mistake that's been going on for 3 or more years or a year or whatever it might be. So
would it be beneficial for someone to retain you to kind of help a lawsuit not happen? Do people do that with you, or how does that work?
They do. I think so. An audit of your HR practices is a good thing too, because that goes broader than that includes wage and hour issues, but it kind of goes broader than that. Do you have policies? If you have policies, are they the right policies? Are they current with California law? All those sorts of things. What are your hiring practices like? Or your applications have the right thing on it? So you can do an audit of all those sorts of things. I don't know that type of an audit would need to be done on a quarterly or more basis. It would depend on if you haven't done one in a while, it might be a good idea to do one if it's been a year or so, or maybe 2 years. The wage and hour stuff, I think, is so much easier to mess up on. And it's so much easier to fix in the short term if you're keeping track of it. So I think that's super important.
We've been talking about California law. What if you're based in California, but you have multiple locations out of the state?
It's kind of a factual question. It depends on, of course, your California employees have to be covered under California law. Correct. And then it would be a factual question as to your out-of-state employees. How often do they come into the state to work? How long are they here? So that'd be a bit of a factual scenario.
I'm thinking of a client of mine who's based in California, but he has 17 different locations, 17 different states. Mm-hmm. So the law is dictated by each state dictates the law in that location, I guess, right?
Yes. Yeah.
Okay.
So wherever those people are located.
Okay.
And then, factually, there might be some questions about, do they travel amongst those offices? If they do, how much time do they spend? So if an employee spends 6 months working at an office in California and another 6 months working in Kansas or some other, or Texas, wherever, then they may be looking at making sure that you're complying with the laws where you're supposed to.
And one of the big things that's out there now is harassment or sexual harassment and discrimination. What can an employer do about that, or what should they be doing?
I think the biggest thing when it comes to preventing harassment, discrimination, retaliatory conduct in the workplace is to be aware and to take any complaint you get seriously. Mm-hmm. One of the biggest things I see, it's always at the manager level. Every deposition I ever took in an employment law case, I typically represented employees. So every deposition I would take on behalf of the employee included most always a supervisor, manager, and the HR individual or the person responsible for HR in the organization, because that's where the biggest problems happen. And when it comes to harassment, discrimination, retaliatory conduct, I think it's important that supervisors are not acting independently, that they're getting backup, because an employee who comes back to work and needs an accommodation, their first line is typically the supervisor. And they say, hey, I'm returning to work. Here's my return to work slip. I need this accommodation. Time after time, I've heard instances where a supervisor said, nope, sorry, can't accommodate. Come back when you're 100%. That's unlawful. And that supervisor acts on behalf of the organization. The other issue comes when an employee comes to a supervisor or manager or anyone else in the organization and says, I feel I've been harassed or discriminated based on a protected classification. Or maybe it doesn't rise to the level of a protected classification. The supervisor really shouldn't be making the decision at that point without some backup from someone a little higher up in the organization or maybe counsel as to what do we do with this. So many times a complaint will come to a supervisor and the supervisor will make an independent decision. Well, that's not harassing. I don't see it that way. Or that's not what you think it is. That's not what that person meant. It's really a bad practice to do that because, one, the organization sometimes never becomes aware of it when it should have. And when there's that opportunity for the because again, the supervisor speaks on behalf of the organization in that regard. So it's better because the organization is going to be deemed liable if it knew or should have known of the harassing, discriminatory, retaliatory conduct. So the supervisor is the front line. They know. Mm-hmm. So it's really important that when they get that complaint, that they take it seriously and that they're not making independent judgments, that they need to pass that up the chain to say, hey, this was brought to me. What do you think? What should we do? And then the people who are, who they're turning to, either HR or higher ups in the organization, need to understand that, well, let's think about this. Maybe let's get some counsel on this. And does it rise to the level? Does it impact a protected classification such as age, race, sex, gender, pregnancy, or something, disability in some way? So I think that's super important.
One of the harassments that's out there a lot is sexual harassment. And the way I see it, and I've seen this happen to one of my friends, is a complaint of sexual harassment can be lodged against someone, whether it's true or not, and you're kind of like guilty till you prove yourself innocent. That's what it seems like. And this particular person I'm thinking of, they were humiliated. Didn't happen. In his mind, didn't happen. She stuck to her story. I think she was on the verge of getting terminated. They were documenting to terminate her. So she came out that way first. He lost his job. They fired him because this was early on when the Me Too stuff was happening and everybody was real emphatic about it. Mm-hmm. And lost his job. Wife was mad because she believed the complaint, of course. They're still married, though. Good. I mean, I'm glad that happened. Mm-hmm. But in the meantime, lost his job, had a hard time finding another job because he had this complaint against him. In their industry, it was such a small industry. Word spread. People knew that he was supposedly a sexual harasser. And he eventually found a job, but it took him over a year and a half to get one. And she just plain lied. But she stuck to her story. Mm-hmm. What do you do in those situations? To me, that's just devastating.
Well, it is. It's super tough. And I think that, when it comes to a lot of that has to do sometimes with the way that it's handled within the organization. So one of the things I always talk about, first off, besides that issue, I think it should never be looked at from a workplace perspective as a gender issue. I think it should always be looked at as a workplace issue. Mm-hmm. And trying to keep that in mind, this idea that take it seriously, but also one of the biggest issues comes down to confidentiality. So until you actually know what's going on, you really do, as an organization, need to try to maintain as much confidentiality as you can. You can never tell someone who files a complaint that we can keep it 100% confidential because you have to investigate.
Right.
And investigations are key. But when I do trainings, I always talk to organizations about making sure that for the most part, when you get that complaint, keep that loop small. I know a lot of managers feel like, oh, I gotta let everybody know. And they shoot out an email and they put everybody in their chain of command on this email. And, oh yeah, I better include this person because we might need to know this and that. And if you have a small organization, that gets around pretty quickly.
And I think that was a problem. There was a lack of confidentiality in regards to this, and word just started spreading within the company.
Yeah, and you can't put the toothpaste back in the tube. That's right. I think that if people are more mindful of that, so stop for a moment and think, okay, who right now, I just got this complaint. Now, who do I need to talk to? Mm-hmm. If it's HR, I need to go find my HR person or the head of HR or whatever it might be, or who handles these complaints. Is it the CEO? Okay, so let me go talk to the president. Let's just have a private conversation. So, and document the fact that you told this person, but you don't need to include 50 million people on the email.
Right.
Or in the meeting that you have. So figure out how you're going to handle it and then talk about, okay, how do we maintain confidentiality and investigate this? What's the best way to do that? Who do we need to talk to? So you might bring in one more person, who's going to be the investigator? Bring in the investigator. Talk about, okay, who do we need to talk to? And make sure you're talking to people on both sides. So it's that's going to really help that part of it. Again, you're not going to be able to keep it 100% confidential, but I think you can minimize who knows about it. And ask yourself, in certain circumstances, I know it's an expense, but it's less expensive than a harassment claim, a legal harassment claim, is considering bringing in a third-party investigator. When I was a young litigator, I never thought that there was much value in that. But I have to say that the more litigations I've had, the more I've talked with employers and employees, I really do think that some situations can benefit from bringing in an independent third-party investigator. Because when you have the organization itself, unless it can truly set aside everything, any prejudgments, anything at all, it's going to be difficult to be impartial. Mm-hmm. In fact, I had a litigation that was at my firm just before I left. And in the deposition, one of the people came in, that was an HR person, and was asked about the investigation that they did. And this person basically said that, well, I asked him if he did it, and he said he didn't. And he swore on his son's life that he didn't do it. And I've known so-and-so for 15 years. He couldn't possibly do what was accused. Well, that's all fine and good, but you don't really know people.
Right.
Harassers don't.
That's a challenge. That's a big challenge.
I mean, you may think you know this person, which is great, and you might. Yeah. And reputation is important, but you really need to set all that aside and take in the circumstances, because harassers typically don't harass in front of other people. And nobody really knows what people do that's character, right? Mm-hmm. What you do when nobody's watching.
Exactly.
So that's what you really can't count on. And that's where you need to be impartial and set that aside. If the organization can't set those feelings aside, then maybe bringing in someone impartial is going to help. It's going to help the organization. It's also going to help that employee who filed the claim to feel like, oh, well, they took this seriously. And then the resolution comes as well, because it's also about closing the loop. So it's reporting, keeping confidentiality, investigating, and then closing that loop, taking remedial action if necessary, letting the employee know, yeah, this is what we did. We did take action, or we didn't find that there was anything actionable.
Seems like a third-party investigator that's skilled in this type of area would be good, because it should bubble up the truth one way or another.
Right,
yeah. Right. Now let me ask you this. Let's say truth bubbles up and it's a false claim. To me, that's back to termination. That's something that you would let the other person, from an ethical standpoint, go immediately. Does that happen, or should that happen, or does she just continue to work, or him continue to work? I mean, how does that?
I think if the organization has a strong history of following their own policies. Mm-hmm. If you have policies that, well, let me back up a little bit. So somebody may complain, and they may have a truly good faith belief that it was wrongful conduct. So you want to be careful, because as long as there's a good faith belief that there was wrongful conduct, then that person's sort of engaged in protected activity. So you need to be mindful of that. Mm-hmm. And you need to be mindful of, can you actually prove that it was a false claim, that there was no basis for it? Because if they had a reasonable good faith belief, they had a reasonable good faith belief. And so you want to be very cautious when you're looking at terminations resulting from an investigation that you did into a complaint. Mm-hmm. I guess my overall comment on that would be, if a termination is going to result based on something you found out in the investigation, I definitely seek counsel before taking action, because you want to make sure that the investigation was impartial, that everyone, all the T's were crossed and the I's were dotted before you actually take that kind of action against an employee.
So as a final question, I just want to ask you, how does an employer stay current and find out more about labor and employment laws that impact their business? How do they stay current on that stuff?
Yeah, I think that's a really good question, because I read a survey of this organization. They surveyed like 300 some businesses, and they found out that it was something like 78% of the small business owners that they talked to said that they got their education on what's lawful, what's not, employment practices from colleagues and friends, which is not good, because they could be just as uninformed as you are. I mean, you may think they're smarter than you, right?
Yeah. Yeah.
So I think that the idea that you're deemed to know the law, so ignorance is never going to be a defense, and you can't shift the burden to say, well, I hired this third-party administrator for our HR or our leave and they screwed up, because the buck stops with the business. So I think that it's super important that you find whatever works for you. So go to a seminar or a workshop, make sure that it's being given by a credible source, subscribe to reliable news sources. There's all kinds of good information, good organizations, both legal organizations put out newsletters and have articles online, and HR. There's some HR organizations that also provide information for simply signing up to their newsletters or what have you. And then one interesting thing you can always do is you can sign up on the California Legislative Information webpage, and you can sign up for alerts so that you get alerted when the governor signs a new law. So you get it firsthand, and you can look and read and see what it says. And a lot of time, law is really complicated, but typically when you get the legislative information, the top of the statute sort of lays out the basics, what the current law is, how this law is changing, and what this is going to require and why. So even just having that little bit of information, I think, is important. But ultimately, I would say when I was in my law firm, one of my law clerks brought me this great mug that said, "Don't confuse your Google search with my law degree." I think they're out there for everything, like my medical degree, but it's true. You can read, you can look up and you can read. The state has a lot of great information on harassment, discrimination, retaliation, all that. But what you really need a lot of times is the practicalities of it. Okay, this is the law. This is what the law requires. But how have the courts been interpreting that? Mm-hmm. Because that's going to have the biggest impact on how you handle it.
Right.
Because the courts are looking at the factual scenarios that are applying the law. That's where you need assistance. That's where you need somebody to say, well, courts are typically finding that this, or they haven't found that, even though the statute says this. So I think that interpretation is super important. So I always think finding someone that you trust to run scenarios by, your particular factual scenario by, is super important. And I also think that one size doesn't fit all. So while you may trust your employment law attorney, they may not know business law, or they may not know much about intellectual property, except to tell you should go talk to someone about that. Mm-hmm. So make sure you're getting the right person, good advice from the right person or the right source.
Thanks for being with us, Teresa. I really appreciate you coming in. To get hold of Teresa, please email me at eb@wait-what.biz, or you can call me at 714-643-2500 at Sitch Radio, and my extension is 420. Thanks, Teresa.
Thank you for having me.
Next week, we're going to have property entitlements, how to get the most out of your commercial property if you're selling it, with Jacob Kala. That's going to be a real good episode. I think everyone will enjoy it, and plus it can add an extra multiple to your commercial property.